Welcome to the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz, your go-to source for insights, strategies, and the latest updates in workers' compensation. Whether you're new to the field or a seasoned professional, we've got something for you. Don't forget to like, share, and subscribe, and or leave a comment. And now it's time to sit back, relax, and enjoy the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz. And good morning, good afternoon, or good evening, wherever or whenever you are listening to us, and welcome to the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz. My name is Steve Appel. I'm a hearing representative with the firm, and what can I say? It's not too often when I can say with a straight face that my guest literally needs no introduction. How would I describe him? He is clearly outspoken. He's impressive. He's one of a kind. He's extravagant. And last but not least, he's extraordinary. What else can I say? But it's my privilege and pleasure to play you my part one of part two interviews with Mr. Phil Walker. And I'm on the line with the infamous Phil Walker. Phil, it's a pleasure to meet you. Well, actually, I met you before. Thank you for coming on the podcast, sir.
Steve, it's a delight to be with you. I love working with everyone from your firm, so this is a real honor and a real treat.
Thank you very much. So, as so many people say, let's start at the beginning. Phil, when did you first start practicing law?
I started practicing in 1981, believe it or not.
I do believe it. And I do. And Phil, did you know at that time that you wanted to go into workers' comp? So many people that go into law school sort of fall into workers' comp, but I think you may be kind of outside the box.
I had never even heard of it. I remember that in law school, I had a torts class, and we had the textbook, and there was a simple asterisk that said if an injury like this happens at work, it's called workers' comp. So I had no idea whatsoever. And when I got into it, my first reaction was California workers' comp is insane, okay? And my second reaction was, they didn't tell me I needed to go to medical school as well.
And Phil, how did you actually get into workers' comp?
It's a very simple thing. I went to a law school named Washington and Lee, which is in Lexington, Virginia. I was practicing in San Francisco. I was primarily doing tax law and some litigation. I was looking for a new job, and there was an alumni of my law school who was in workers' comp. He did longshore cases, so I applied to him, and he hired me.
And of course, Longshore has been using the AMA guides for a long while, but in California workers' comp, we only started with the new AMA guides in the reform about 20 years ago, right?
That's exactly right. Through Longshore, I've worked with the 3rd edition, 4th edition, 5th edition, and I was actually a consultant on the 6th edition in order to help them get their language clear, because doctors have a very difficult time writing clear language.
So, Phil, I have to ask you, Phil, and I just thought of this now. If you have a deckhand, or maybe even the captain of a ship who is going down the ramp and he slips and falls while attempting to get on the ship, when is it longshore and when is it regular workers' comp in California?
It's a really good question. And let me just tell you that it's a very slippery question. I'll just give you a simple example.
We love all attorneys love the slippery slopes, right, Phil?
Yeah, exactly. If there's a person on deck and he's hit with a flying winch and he's killed because it happened on the boat, it's longshore. If he's on the deck and he's hit by a flying winch and his body is thrown onto the land, that's California workers' comp.
What about dry dock?
Oh,
Ah.
such a good question.
And for those listeners that don't know, dry dock is generally when a ship is being fixed for whatever reason, but is it not necessarily on water? Is it on land? Or could it be on water?
There are floating dry docks,
Exactly.
which are commonly used, and then I've never actually seen a dry dock on land, although I do believe that when ships are built, it would qualify as that, a dry dock on land before they are launched. But the simple answer to that is any injury there in the ship building process,
Yes.
including on the vessel or getting on the vessel,
Yes.
even if it's in dry dock, that is longshore jurisdiction.
Excellent. So what happened next as far as the start of your career? Yeah.
So it turned out that this man, my mentor, had been the chairman of the Benefits Review Board, which is the equivalent of the WCAB in longshore. So he was a great trainer and he taught me how to defend longshore cases. And then what happened is there were other people in my firm who did California workers' comp. And slowly it became necessary for me to learn California workers' comp because often there were cases that presented questions of dual jurisdiction.
And for the listeners that don't know, longshore is federal jurisdiction. Now, you're the expert, I'm not. I presume that means that the longshore rules and regs that apply are exactly the same in all 50 states, or no?
Yes.
Yeah.
Yes. And it also means that I could move to a state where I don't have a bar, but I could still go into the longshore courts. Because if you have any bar in any state, you are entitled to practice in any federal jurisdiction.
Would you have to petition, I believe it's called pro hoc vice, if my memory serves? Yep.
No, it is called pro hoc vice. You do not have to petition for that because fundamentally, by having a bar in one state, you are admitted to any federal court, including, well, I should say this, any federal administrative court. And that's what longshore utilizes.
And so what happened next?
So I began learning California workers' comp. And let me tell you how I learned it. The senior partner came in. He had one of the labor code books in his hand, and he put it on my desk. And he said, read this.
Damn, Phil, I got to tell you, that's exactly how I started to learn workers' comp over 30 years ago. My father, who's a retired work comp attorney, he threw on my desk a copy of the labor code 30 years ago, plus he photocopied about 50 pages of case law and general decisions, and he said, Steve, learn this. I'm sorry to interrupt you. Please continue. That's exactly how my dad taught me.
No, and then what happened? And so literally, I truly didn't have a clue. I was with that firm for about 2 years and primarily did longshore. But then I got hired by U.S. Steel to be their workers' comp counsel for the Western United States, from the Rocky Mountains to the Pacific Ocean, from the Canadian border to the Mexican border. And I handled the workers' comp cases in each of those states.
And approximately what size was your caseload at that time?
It was about 200 cases at that.
And it's sorry to interrupt, but I know that prior to we talked about the 2005 reform, defense attorneys had a caseload maybe 150, give or take 125, maybe a little higher. But since the reform, the defense attorney caseloads have gone down to about 75, 80, 85. Is that your experience?
Absolutely. And let me just tell you, that is beyond wonderful because I'll really tell you something. In the beginning of my career, I felt like a rat on a treadmill because as soon as you finished one case, you were on to the next. And you were,
Going around in circles. Go ahead.
that's right. And you were doing appearances every morning, every afternoon, depositions. If you were in Northern California, you could have to drive from San Francisco to Sacramento. If you were in Southern California, you could have to drive from Anaheim to Ventura. And then you had to do doctor depositions, which in Southern California, they always scheduled on Santa Monica Boulevard at 5 p.m. on a Friday.
Phil,
To
at
make
that
sure.
time, how long did it take you to get those hearing reports out?
Oh my God. What I would have to do is I didn't have time to get them out during the week.
Right.
So I usually had to come in on the weekend and dictate them. And ultimately, I learned to try and block out days where I could be in the office. But the problem in workers' comp is you don't control your schedule. Okay. And the court sends out the notice of hearing and you have to be there. And in those days, we had to be present and we wore coats and ties. And we all carried these giant briefcases
Yep.
that weighed easily 50 pounds.
Yes,
I went to get
when somebody invented the wheels on the briefcase and then a
oh
handle, that was a beautiful
oh
thing, right?
it was a miracle, and I kept thinking, why didn't we think of this earlier? And I went to get a suit fitted in Hong Kong, and the tailor told me that my right shoulder was 1 inch lower than my left, and it was because I'd been carrying this briefcase.
Um, so what's the longest amount of time it's ever taken you to get that hearing report out? I know occasionally for me, unfortunately, it's a couple of weeks, and then not only do I forget all the information,
Yeah,
not only do
yeah,
I have to recapture my notes, but that is the inevitable albatross around my neck, you know?
yeah. The truth is, a month.
And did you have your client calling you saying, "Where's my hearing report?" And then you called back, I'll
No,
get, no, no,
no,
no, no.
no,
They trusted you.
no,
They
no.
trusted you.
Well, they trusted me, but also I always wondered if they actually read the hearing reports. And because I'd ask them to do things and they wouldn't get done. And I will tell you that one of the greatest challenges I've had in workers' comp has been working with claims examiners with no training. I certainly work with fantastic claims examiners over my career, but I always thought it was a little challenging. When I had been a practicing lawyer for 25 years, and some little claims examiner who had 6 months of training was telling me how to handle the case. And the greatest thing I learned from that was this: the number one cause of litigation in workers' comp is insurance companies denying appropriate treatment. I had a case where the diagnosis was possible fracture of leg. The claims examiner denied an x-ray. Okay? And so I found out, and maybe you want to say for the defense, it was great. As soon as the medical was denied, the applicant went to an attorney and the litigation started. And the case always cost more than if it had not gone to litigation. Now, let me say that 95% of the claims examiners I worked, well, 90% were great. But trust me, there are insurance companies that only provide 6 weeks of training to people. And this is to people who have no background. Now, I know listeners may not like to hear that, but there's both good and bad in the world of workers' comp, and I call that bad.
And that is the first half of part one of my two-part interview with attorney Phil Walker. You're dialed in to Work Comp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appel. I'm a hearing representative with the firm. And this is a very good point to say it starts to get a little dicey now, folks. So the opinions expressed by Mr. Phil Walker are his opinions and his opinions only, and do not reflect either my opinions or the opinions of Schlossberg and Umholtz. Please remember to like, share, and subscribe. And with that, we'll continue with the second half of part one of my interview with Mr. Phil Walker. All right, Phil. So we've been talking about how you got into workers' comp. Let's advance up to how you got to your specialty of being an expert and an expert witness in AMA and permanent disability guidelines. I am assuming that happened because of the 2005 reform.
That's right. And many of the younger people in our practice do not know that the 2005 reforms came into the law because workers' comp premiums had increased over 400% in 5 years. And this is because judges were awarding things like spas in the backyard, maids to take care of people, paying the wife to be a caregiver.
How about, Phil, literally hundreds of thousands of dollars in retro VRMA? I assume a lot of our new adjusters that are listening and our new defense attorneys don't even know what that is.
Well, if you hadn't done voc rehab correctly,
if you haven't given a notice, if you didn't send out one letter, the clock starts running. Yeah,
that's exactly right. And you'd be facing thousands, tens of thousands of dollars.
Phil, I once had in one of my cases a rehab plan that involved giving an applicant a bachelor's degree at the University of Hawaii. I just had to throw that in.
Yeah. Oh, no. I gave bachelor's degrees all the time. I had a rehab plan for a woman who wanted to become a massage therapist. We gave her the plan, and then it turned out she was essentially a hooker. Only in workers' comp, and quite candidly, I stick all of this on the judges. Okay? I've been in this 43 years, and I call it as I see it.
And Phil, I got to tell you, because some judges listen to everything I do. I like the work comp judges. I give them total respect. Okay, so Phil, just be careful. Otherwise, I would never tell you that. But I like my judges. Go ahead.
Okay, great. Okay, so when the reforms were done, they included the AMA guides because they were trying to create uniform PD ratings for the same injury from San Diego up to the top of the state. Because before that, the ratings varied incredibly because we had this insane system
known as subjective factors, with like a 60% permanent disability standard for a semi-sed that had no objective factors, right,
Bingo.
Phil?
Bingo. And the subjective factors would be, he hurts on Thursdays, but when he bowls on Fridays afterwards, he has a problem. And he is able to ice skate, but he can't ballet dance.
And then a good defense attorney with those facts would recommend to the adjuster to go get Sabrosa. The adjuster would get Sabrosa from an investigator, showing this guy working on his car for a half a day, lifting 100 pounds. But then at trial, the applicant attorney would bring out testimony that that was only one day in the month that he did it, and he was on his pain medication, right?
Exactly. And so the judge would ignore the sub rosa. So what you had to learn to do was you didn't show the sub rosa in court. You took it to the doctor's office and you showed it to the one who had given him all the limitations. And in about 90% of my cases, then you ask the question, doctor, do the activities appear to be consistent with the limitations you've given? Well, no, they don't. Doctor, do you think you should change your limitations? I think I need a reeval. And then they'd bring them back for the reeval, and they'd always cut the restrictions massively. Why? Because the doctors don't like being lied to, but they don't like being made a fool
Yes.
of.
Phil, that's a great segue to the next question. When a defense, or for that matter, an applicant attorney, is taking a doctor's deposition, my dad always told me there are two ways to change a doctor's minds. Because the one thing that doctors don't want to do, as you said, be made look like a fool. They don't want to write something down in a report, which is there forever, and then go back on it. So, number one, Dad always said you need to provide them new information to give them a
Yes.
road to go down to. But number two, to give those hypothetical scenarios. What are your thoughts, Phil?
There is a third way, and this is the most effective, and this is what most workers' comp defense attorneys don't know. You go online and you search the medical literature, and you bring copies with you. At some point, we're going to talk about left ventricular hypertrophy.
We're gonna do that. We're gonna do that in part two. Yeah, go ahead.
Correct.
Go ahead. Yeah.
It turns out that 90% of those patients can be treated completely successfully, and they can recover in 11 months. And here's the God's honest truth. I've never seen a cardiologist in California workers' comp admit that. Until you go in the deposition, you slam the medical literature in front of them, and you say, Dr. Ho-Ho, have you ever read this report? Did you provide the appropriate treatment? How can you say they're at MMI? Because under the guides on page 19, the patient is not at MMI until all medical treatment has been given, which could improve his situation. And I teach people to do this in the deposition. And about 2 weeks ago, I had an attorney call me up and say, oh my God, Phil. I sent them the medical literature articles, the attorneys.
I was just going to ask you, Phil, how often do an opposing counsel object to the question on the basis that you're providing not only the doctor, but opposing counsel with that documentation? You did not provide it in advance.
You're totally permitted to do that in a deposition. As far as I know, with procedure, if you want to, though, you could send it to the applicant's attorney. Trust me, they'd freak out. Okay? But you could send it to them. I've done it a million times in the deposition because you ask the doctor if he's familiar with that. And just like we were talking about, he doesn't want to be made to look like a fool. But he's a fool if it's his specialty, and he doesn't know treatment can make people recover.
So tell us more about how you got into your specialty of AMA and permanent disability expert witnesses.
So when the reforms occurred, the AMA guides were adopted to try and create a more consistent system of rating. And it turned out that the only people who had worked with the guides before 2005 were longshore attorneys. Well, I was both a longshore attorney and a California workers' comp attorney. And after the guides were adopted, no one knew how to use them in California. I mean, no one in California workers' comp. So my phone began ringing on the hook. Can you come down and train us? Can you come down and train us? And the end result was I actually hitched up with Dr. Christopher Brigham, who was one of the authors of the 5th edition.
Yes.
And for 2 years, we trained across California 120 days each year. And through that, He taught me the guides, one of the authors. He introduced me to the authors of every chapter so I could ask them any questions that I wanted. And I literally learned it by the people who wrote it. And I trained, and then what would happen is the claims examiner or the defense attorney would call me and say, I've got this report. Can you help me with it? And I said, sure. And I'd go through the report and find which rating was correct and which was incorrect. And I'd calculate the value of the report in terms of what the current ratings are from the doctors, what the correct ratings are, and how much money you can save. And often the saving would run from $35,000 to $3 million. Okay. And so this happened to me so frequently. I said, I need to start a business. And I began doing these ratings. I charged $385 per 29 pages of medical report. And one day out of the blue, I had done a, what do you call it? A spreadsheet identifying who the worst doctors were in California.
And you're not going to name them on this podcast.
No, I am absolutely not. But I then got a call from the head of the University of California Workers' Comp, and he said, we would like you to do every permanent disability rating for us for all campuses for UC.
And this was about what year?
This was 2007, basically.
And
yeah.
I presume that was the majority of your caseload. Were you concerned that if you lost that client, God forbid, it might be the end of your practice, or was that not a concern for you?
No, because what I ended up doing was hiring 5 people to help me. They were all lawyers. I trained them in the guides. And I also had a ton of reports coming in from other clients. I totally understand what you are saying. This is one of the great dangers for lawyers, is that you get a client who takes up 80% of your practice and then they decide to leave.
That's the old 80-20 rule in business.
Yeah.
That 20% of your clientele makes up 80% of your revenue.
And I know one special employer that I refused to be the attorney for, who what they would do was take over 80% of your practice and then push you to reduce your prices lower and lower and lower.
Yes.
And this was their technique. And I knew it. And they came to me and said, we want you to be our workers' comp lawyer for Northern California. And 2 things happened. I knew their game, but I went out to train their claims examiners. And I asked them, how do you decide if the doctor's report is correct? And the claims examiner said, we just pay whatever the doctor's report says.
Amazing. Phil.
I've never forgotten that moment.
Phil, we're going to have to take this interview into part 2, because in part 2, we are going to talk about specifically what are the issues today with permanent disability, AMA guides. And before we end this interview, would you like to give your contact information for the listeners?
Yes. My email is Phil, Phil, at ask, A-S-K, Phil, Phil, Walker.com. My cell phone is 415-816-3527. The evaluations I do tell you what the current ratings are and how much money you can save. And what every error is in the guides. I also help people outline what their deposition should be with the doctor. I provide medical literature on any condition that I'm dealing with that people aren't familiar with. And then I also work with people on strategy. After 43 years in this business, I know 90% of the tricks in the book.
And that is the end of part 1 of my 2-part interview with attorney Phil Walker. You're dialed in to Work Comp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appel. I'm a hearing rep with the firm. And if you enjoy what you're listening to, please like, share, and subscribe. And please join us for our part 2 interview with Phil Walker. Take care, everybody, and thank you very much for listening. You've been listening to the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz. The opinions expressed on Work Comp News and Views are for entertainment purposes only and not to be considered legal advice. Don't forget to like, share, and subscribe, and/or leave a comment. Also, feel free to send an email directly to sappel@schlossberglaw.com. For Work Comp News and Views and Schlossberg and Umholtz, my name is Steve Appel, and thanks for listening.